Hello, welcome. This is Crime in Court. My name is Heather, and we are here with another Delphi update. This is in response to my latest video on Delphi, which was a filing from the prosecutor Nicholas McClelland, asking for both of Richard Allen's attorneys to be held in contempt of court. So this is a response from Bradley Rozzi to the court regarding that motion, and also it is he's asking for a continuance, and you'll see several reasons throughout why he wants to continue the scheduled hearing for this, because almost immediately Judge Gull came back and scheduled a hearing for it. But yeah, we'll get into that. Okay, so motion for continuance comes now. Attorney Bradley A. Rozzi and respectfully requests that this court continue the February 12th, 2024 hearing of the verified information of contemptuous conduct filed by prosecutor Nicholas C. McClelland on January 29th, 2024. In support of said motion, counsel states as follows. On January 29th, 2024, prosecutor McClelland filed a verified information of contemptuous conduct. That's the motion that we read through. Within said information, prosecutor McClelland alleges that Attorney Rozzi engaged in conduct that amounted to indirect contempt of this court's orders. 3 days earlier, this court scheduled the state's information for, 3 days later, this court scheduled the state's information for hearing on February 12th, 2024 at 9 a.m. in the Allen Superior Court. So like I said, she came back almost immediately. I think it might have even been after a weekend or something. She came back 3 days later and was like, yep, you can have your hearing for contempt of court, but Brad and Andy, Allen's attorneys, have already put in a motion prior to that, prior to Nicholas McClelland's motion about disqualifying Judge Gull. So that needs to be heard first before anything else that takes precedent. So February 12th hearing was scheduled by the court without any consultation with Attorney Rozzi's office regarding Attorney Rozzi's availability. Attorney Rozzi is scheduled to be out of the state of Indiana on personal matters and is therefore unavailable to attend. So that's interesting that she just scheduled it. And yeah. All right. Because of the timing of the state's filing, Attorney Rozzi has only 11 days to prepare for said hearing. Attorney Rozzi has yet to consult with an attorney as of the date of this filing of this motion. The accelerated scheduling of the hearing prohibits Attorney Rozzi and or his future legal representation from conducting any meaningful discovery regarding the state's allegations, which appear to have stemmed from a side investigation into leaked photos. See paragraph 1224 from the contempt pleadings. That was conducted by the same investigative team that investigated the crimes in this case. It seems only fair that Attorney Rozzi would be entitled to conduct discovery on such a matter before facing sanctions and could result in Attorney Rozzi's imprisonment. Like I said, he could face fines or imprisonment and or both. That's why this is really important, that he has more time to defend himself. So Attorney Rozzi would further report that the moving party, Prosecutor McClelland, has communicated to Attorneys Rozzi and Baldwin that he will no longer engage in telephonic communications with Attorneys Rozzi and Baldwin in this case. Prosecutor McClelland has limited all communications through email correspondence. Therefore, the flow of information between the state and attorneys Rozzi and Baldwin is limited. So, what do you guys make of that? What do you think of the fact that now Nick McClelland refuses to even communicate with Rozzi or Baldwin via telephone? Why do you think that is? Why do you think he's trying to limit communications with them? All right, so number 8, a plain reading of IC 344736, the statute articulating the potential punishment to be handed down by the court in a contempt finding, authorizes the court to punish indirect contempt by way of fine, imprisonment, or both, a fine and imprisonment. As such, Attorney Rozzi is entitled to obtain representation for purposes of defending against the allegations of contempt. An indirect contempt, which is at issue here, requires an array of due process protections, including notice and the opportunity to be heard. So they need enough notice to gather the information, gather the discovery that they need, and, hire an attorney if he needs. He needs time to do that, and he can't do that with such a short turnaround, and he's going to be out of town, number one, when the hearing is scheduled. So it just makes sense that they move it. I can't see why they would deny this, but you never know. All right, so regarding Nassar, 1994, surely these protections would amount to more than 11 days of advance notice. So, yeah, in order to protect yourself fully from imprisonment, you might want more than 11 days to prepare for that. The allegations in the state's information fail to accurately categorize the contemptuous behavior as being grounded in either civil contempt or criminal contempt. Therefore, the pleading was filed within the MR cause number and not in an unrelated civil miscellaneous MI cause. So that's the way that they file things within the courts. So moreover, the allegation is couched as an information for contemptuous behavior as opposed to a citation for contemptuous or for contempt, and therefore it is logical to conclude that the relief sought by Prosecutor McClelland is akin to the associated with criminal contempt. So he's saying to me, it's more this is more of a criminal type of contempt that Nicholas McClelland is trying to get for these guys. And while the information does not specifically contain a prayer for relief, the pleading does reference the revictimization of the victims' families, which is immeasurable and incurable. This verbiage is grounded in criminal contempt. So he's, again, citing that that's what he thinks Nick McClelland's intentions are behind the filing. Therefore, Attorney Rozzi is entitled to the appointment of a special judge pursuant and logically the process of selecting a special judge should occur before any hearing on the allegation, before any hearing on the allegations take place. Okay. He's entitled to a special judge, a newly appointed judge, not Judge Gull, to oversee this hearing, and that should take place, obviously, before the hearing takes place, is what he's saying there. Attorney Rozzi would also note that on January 28, 2024, defendant Richard Allen, by and through his attorneys Rozzi and Baldwin, filed a verified motion to disqualify Judge Francis C. Gull. It is well settled that when an affidavit for change of judge is filed in a proper case based on the bias and prejudice of the judge, it takes a second for it to turn over. The court has no direct discretion in this matter. So, judge has no authority. They can't use their discretion in this matter. Moreover, in Ballard, This is the case that they're citing. The court cited the defendant for contempt for failure to comply with an order issued by the court prior to the filing of the request for the change of judge. This factual scenario is nearly identical to the one that exists in this case. Remember, Nicholas McClellan is saying that they violated a gag order, even though the gag order wasn't even instituted until after the fact. So that's what he's saying here, and it happened in this other case too. So Attorney Rozzi asserts that at the present time, this court has no authority to conduct a contempt proceeding of any nature. Because they put in this motion to disqualify first, the court, Judge Gull, has no authority right now to rule on anything, pretty much, because as I understand it, the motion to disqualify, Judge Gull takes precedent. It was filed first, and that needs to be heard. Unfortunately, it is heard by Judge Gull. Judge Gull decides if she removes herself or not. So that is the problem there, and a lot of people are already claiming bias, so we'll see what happens, but I don't know, because she hasn't even scheduled a hearing for that. She might just deny it without hearing, if that's probably what she'll do, but I don't know. We'll see, because we know that the Supreme Court is watching too. So Attorney Rozzi would further note that there remains pending the issuance of a full and final opinion stemming from the Indiana Supreme Court. Well, there you go. Their published order of January 18th, 2024. So they came out with a brief, rendering of what their judgment was, but they didn't write their full write-up and give case study and all that. As for the reasonings, why they made the decisions, they made the decisions public right away because they wanted to reinstate, because of the urgency of the matter, they wanted to reinstate Rozzi and Baldwin. They denied throwing Judge Gull off the case, and they denied Allen his fair trial or speedy trial reset, like the clock resetting on that. So that's unfortunate, and Gull is still on the case. So we'll see what happens, but we're waiting still on the final write-up. So it seems only logical that no further action regarding the allegations of misconduct should occur until the court issues the full opinion giving further guidance regarding the order reinstating and attorneys Rozzi and Baldwin and the procedural circumstances surrounding this case. So it does make sense to want to find out what the Supreme Court, what their findings were, what their rulings were before you start ruling on everything, because Judge Gull came back and immediately she denied every outstanding motion from Richard Allen's attorneys in one motion, one sweeping page motion without any case study. She just said denied. So I don't know. So it seems only logical that no further action regarding the allegation of misconduct should occur until the court issues the full opinion giving further guidance regarding its order reinstating attorneys Rozzi and Baldwin and the procedural circumstances surrounding this. Ironically, the anticipated opinion in this case stems from the filing of an original action, which was also the case in Ballard, referenced above. So the other case that they're mentioning. So therefore, there is precedent that the conduct of a trial court judge in the face of a pending motion to disqualify is appealable in the form of an original action. So they can appeal. There is no harm in waiting the opinion of the Indiana Supreme Court, affording Attorney Rozzi the opportunity to consult with and retain counsel, allowing Attorney Rozzi an opportunity to conduct discovery on the state's allegations, and most importantly, adjudicating Richard Allen's motion to disqualify. So that is of the utmost importance, is the motion to disqualify. That comes first. He's reminding the court, You don't have authority to rule on this. This needs to wait after we get the filing from the Indiana Supreme Court. Plus, I need to find my own attorney, and we need to do our own discovery, and you're just not giving us enough time. So this was, I just wanted to show, this is a screenshot from the Indiana clerk of court's website, whatever, when they showed new filings on there. So this last filing was February 2nd, so just last Friday. They filed, and we shall see what happens. It is, I don't have a whole lot of faith that Judge Gull is going to grant many or any of the motions from Richard Allen's attorneys, because it seems like she's quite biased. So we'll see if she comes back and gives the guy, the poor guy who's not even in town, give him a continuance, or if she's going to try to lay down the hammer and be like, nope, sorry, that's the only day the court has available, which I think that would disregard his right to due process. So as he stated in his motion, he's entitled to due process, and all of this, he needs more time. So we'll see what happens with that hearing. It's going to be interesting either way. So let me know what you think. Do you think this hearing will take place on the 12th, or do you think there's going to be a continuance? Let me know in the comments below. Be sure to like, comment, and subscribe, and I'll see you next time. Take care.